You want me to present shortly what I do, or
Sure.
Okay? So currently, I'm an associate at Goldfarb and Seligman law firm. I'm doing public international law practice, which means specializing in consultations and litigation, or preparation to risk assessment and litigation for private institutions, as well as corporations, governments, and so on. But also doing regular litigation like any other lawyer. I just returned from Geneva, so I've been in Geneva for 8.5 years, and there I did both my LLM, and hopefully by the summer I'll be formally finalizing my PhD at the law faculty, specializing in humanitarian law and human rights, and criminal law. During that time, I also worked as a researcher and a teaching assistant lecturer at the Geneva Academy, but also worked as representing NGOs with the Human Rights Council in Geneva and other UN subsidiary bodies, also in Paris and in The Hague. Okay. So when Ido and Michal asked me what I wanted to talk about, I said I'll choose one of the two topics that I centered during my research in the past years. One of them was the law of occupation, but that's kind of, I find it a bit boring or very political. It turns to be very political, or the question of
Political, of course, isn't boring.
Isn't boring at all. But then I realized that one of the main questions that I had to ask myself during several of my research, and is still being asked, is how do we treat armed groups? So generally, how do we treat non-states? So what are actors, non-state actors? And we call them actors, which is funny because there is no such notions in terms of legal personality in international law. Actors. What do we mean by actors? What's the playground? But more specifically, we tend to address armed groups, but we never ask ourselves, can we address them? Or how should we address them? Or how the law addresses them? And it's an important question, and it's been dealt with in the past, I think, 2.5 years in many books. Not many, that much, but Catherine Fortin published one, and then just a year before, Catherine Darag-Mouret published another one, both of them dealing with accountability of armed groups in international law, and specifically within the framework of international human rights law. And for me, coming from humanitarian law, it's always a question because, okay, we have humanitarian law, but then comes what? What's the end game with international law? And so one of the questions that I ask myself frequently is whether there are object, so they're part of international law, but they stand there, or they have a personality and they're subjects. And there's a reason why an object is something that is singular, individual, stands alone there. We walk around it, and it's part of the view that we have, but it's not something that we treat as members or subjects. Are armed groups truly subjects of international law? Can they be part of this playground? So I have a short outline. Hopefully will meet my expectations. I'll first ask First, I think what we will ask ourselves is who are subjects of international law and why? Why do we look at them that way? Then we'll shortly go to the different possible definitions of armed groups, and we'll ask ourselves also why is it relevant to define them? So what's the purpose of defining armed groups? And whether the definition is connected or disconnected with thresholds of legal frameworks, different legal frameworks. And then I'll suggest the implications of treating armed groups as subjects of international law and not just as an object standing there that we can walk around it. I suggest that if you have a very important remark while I speak, then yeah, please do. But otherwise, please bear with me for approximately 40 minutes, and then we'll have an open discussion. Is that okay? Great. So just setting the framework. Who are subjects of international law? So generally we speak about states. States are subjects of international law. They ratify treaties. They make the law, they vote, they go to war, they change the law. I mean, it's been centuries that we see states as it, and it's a philosophy, it's a whole theory in international law, saying states are the main actors. They are the subjects, they create the law, they make the law, they apply the law, they change it, and they break the law. I mean, these are states. And now the question is whether whatever happens inside of states is, the interest of the international community, or whether it's kind of a curtain, it's a billiard ball, like it's a ball, it's a bubble, and it's untouchable. But in any event, we do agree that states are the one playing the game. Now, in recent years, and maybe since 1922 approximately, when the League of Nations started to be active, but more so after the UN, after the establishment of the UN in 1946, the question that we have is whether international organizations, and obviously there's the difference between NGOs, so non-governmental organizations, and international organizations based usually on treaties or agreements between states, whether they are subjects of international law. Generally, we tend to say, well, we're not sure they're subjects, but they have an effect. And theories in past few decades, and the last 2 or 3 decades, kind of went into the tendency of saying, you know what, international organizations, they're not states, but we can sign treaties with them. We can have a bilateral treaty. I mean, Israel can have a bilateral treaty with the EU. The EU is an IO. It's not a state. It has the power because states are a member. They've established it. Well, we can sign a treaty with the EU, and it would be perfectly fine. I mean, it would be applicable in the arena, in the sphere of international law. Do we have other players, other subjects, other organizations or institutions, or that are not just there, but can actually shift the discussion and change it? Some tend to say that NGOs are, so non-governmental organizations. Obviously, we cannot sign a treaty with an NGO, but they do affect international law. I mean, look at the Ottawa Convention from, 1997, is it? Yeah, it's 1997. The Ottawa Convention against anti-personal mines is a convention that was pushed forward by NGOs that were unpleased with what came from the discussions around the CCW. So that's a good example. But they couldn't make the law, but eventually they were the one pushing it. So are they subjects of international law? Or can we find another definition, another term to use versus these players that are not truly subjects, but they do affect whatever is going on in the international arena? And I think it was both Andrea. Oh no! Don't restart now. I think it was both Andrea Bianchi and Crawford. Both of them said, "Well, you know what? Maybe we can call it actors. So instead of going through the theory of subjects versus objects of international law, maybe we can say actors. Everyone who acts within the international legal framework of the world, of the globe, and affects international law and affects international relations, and they act, and then we can measure them on a spectrum between how active they are. So obviously states, they're like major players, but we have others. And the more we realize that NGOs and other non-states are affecting or playing in the playground and playing well, and the more we realize that law is not as rigid as states are, and there is some margin to play with it. Now, unfortunately, while most states, not all of them, but most states are fine with NGOs being part of this playground, they're not so fine with having armed groups as part of it. So now let's ask ourselves, would we agree with armed groups being actors? Why would we want them to be actors? And the main question is that while subjects of international law and states generally, but currently also international organizations, we have some precedents in that, bear some accountability. So they can be they can be held accountable for actions in the international sphere. Most people tend to say, well, you know what, armed groups aren't. They're not accountable. We don't have any body of law, and we'll discuss it further on in the following, but we don't have a body of law that holds them accountable in the classic approach of accountability.
Individuals are.
Individuals are, exactly.
So any group of several individuals can be accountable.
Okay, that's a great approach, right? We can hold them accountable for criminal purposes in criminal tribunals, domestic and internationals. But states, they're a bunch of individuals, but states can be held accountable in international. You can take them to the ICJ. They might be held under a regime of sanctions. They can be voted on or regarding to their actions in the Security Council, and they're part of this discussion, while armed groups are both being perceived as not being part of this discussion, but I'm not sure we also want them to be part of this discussion. While I say we, I would really like them to be part of this discussion, but I'm talking about states. I'm not sure all states are willing to give this place or to give armed groups their seats around the table. Now, how do you define a legal personality? So the question is, well, you can be held accountable if you have a legal personality in the legal regime, in the legal framework, in the playground. But how do you earn, or how do you define whether an object or someone has a legal personality? Darag Murray wrote that one could say, well, he based himself actually on a theory saying, well, do they have the capacity and the ability to comply with international law? And if they have both the capacity and the ability based on treaties or on custom, then they could be. And then he added to it a possible condition or indicator in that sense. Are they independent? So are they connected? Are they linked to a state? Can they stand alone or not? The problem with it is that some groups, or some even de facto regime that we consider them to be very strong actors and subjects of international law, are not independent at all. But they have the capacity and the ability to be part and to comply with international law. So, is it possible that only those with legal personality can be held accountable under international law? I'm not sure I agree with it, but I'll divide the following into two steps. The first one is to define whether we have a source to consider armed groups as having legal personality within the legal frameworks that we want them to follow. And then the next step would be, do we need that? I mean, is accountability limited only to those with legal personality? So we can define armed groups, let's start like that. We have one source of definition for armed groups that is a classical source. That's international humanitarian law. And why is that? Because actually, in the treaties of international humanitarian law, it is armed groups are explicitly addressed. They're considered to be part of they can be a party to a conflict, and therefore they're defined in international humanitarian law, they're addressed in international humanitarian law, and they're expected to comply with international humanitarian law provisions and regulations. We have Common Article 3 that states that define the threshold for the applicability of the Geneva Conventions. Now, the first question that I think we could maybe ask ourselves is whether complying with the threshold of IHL automatically means that only after the threshold applies, an armed group exists? That's a good question. But before, let's stay classic. Let's start with the definition provided by courts, tribunals, scholars, and the treaties themselves. Armed groups should be organized. If they're not organized, IHL does not apply to them. So one can revert and say, well, an armed group, that is a player in the field of armed conflict, is organized. What do we mean by organized? They should have a commander. They should be identified in some way. And in many cases, in the travaux préparatoires specifically, they kind of mixed between organization and intensity, requiring also some sort of ability to hold concrete military operations, which requires, in a sense, both organizations, so some sort of coordinations, organization, command, responsibility, and so on, but also some sort of territorial control or a base to go to. So somewhere that they can prepare and organize and train and so on. Because otherwise, if they don't have that ability, they're not able, obviously, to act, to hold concrete military operations. And then the intensity, which incorporate exactly that, the ability to hold concrete military operations, but to a certain extent. So to a certain time. It's not only time. As you know, there's been a bit of an argument in the ICTY already in the 90s between what then was perceived to be protracted violence, so that goes for a while, that goes on for a while, and intensity that said, well, we don't know for how, we cannot judge at the moment for how long the violence will go on, so we have to find something that is more that is definable at the moment, and that would be intense. That would be whether the violence is intense or not. And how do we measure intense? Again, can we hold, or can we provide for a military base? Is there a territory that is controlled? And one of the main tests for that is what types of weapons, means and methods that are being used by both parties. So by the armed group itself, did it obtain weapon? Is it able to actually hold heavy weapons, guns, and so on? And or whether the state has to use more than its law enforcement, regular law enforcement officers to contain the violence. So organization and intensity, that's Common Article 3. I'll come to that later, but there has been a debate, and it's still somewhat vivid, whether putting the Common Article 3 threshold of applying IHL too high is not the purpose of identifying non-international armed conflict and identifying armed groups, and takes out situations of violence that should be, takes out situations of violence that are, that should be controlled, should be regulated by international humanitarian law. But I have a thought of that, but bear with me a bit more. And then we had Additional Protocol 2. To be honest, the only thing that Additional Protocol 2 adds that is relevant to the definition of armed groups is that it requires it to control territories. Explicitly requires it to control territories, but it attaches this requirement to the ability to comply with IHL and the ability to hold concrete military operations. So according at least to Additional Protocol 2, it would be almost impossible for an organization, an armed group, to be considered an armed group and hold military operations as well as comply with IHL if it doesn't exercise some sort of control over a territory, which is, if you think of it, kind of rational. You're not able to ensure the compliance with IHL if you don't have anyone that you control. And of course, if you want to hold concrete military operations and you want to be able to push forward your military aims, then controlling a territory is necessary. at some level, even in a small military base, not controlling a vast territory, but actually having somewhere that you can go back to and train. But it's controversial. So not everyone thinks that an armed group requires territorial control in order to be an armed group. And then the question also falls, and I think Siva Kumaran discusses it vastly in his book from 2012, where he asks whether territorial control actually means a vast territory, like something that is truly a state or land, something like ISIS, or having just a headquarter suffices for that purpose. I would go with the latter, that even just having a headquarter suffices to say that one controls a territory. But, okay. Now, IHL, it's classic. IHL recognizes explicitly armed groups. The question is, can we define armed groups outside IHL? Now, my question is, should we? Should we define armed groups outside of IHL context? But I'm not the only one in this. I'm not the only scholar, and people do believe that armed groups should be defined, should be addressed outside of. And it's not only believe. Practically, we can see that armed groups are being addressed outside the context of, or in subsidiary bodies, committees, councils, organizations, by states, by tribunals, regardless of whether you address or you have jurisdiction over the conflict. And so it is interesting to ask ourselves, so what's the source of such definition? So I'll give you an example. Some claim that Boko Haram, an armed group, active in different areas, but mainly Nigeria, has been active way before there was an armed conflict between the group and other military forces around it. Therefore, when looking at Boko Haram, the definition should not rely on international humanitarian law. Same goes to armed groups that operated in Syria before February of 2012, where at that moment most of the international community recognized that there exists a non-international armed conflict. So the threshold of IHL has reached, at least according to the ICRC and the Chatham House report, it's around February 2012, and also the Human Rights Council addressed it as such. So from February 2012 onward, a non-international conflict occurred in Syria. But what's the source of the definition? What's the source of addressing armed groups before that time? I would say that as we use the term armed, it is difficult to detach the definition of armed groups from a context of violence and conflict. And that at a certain point in time, the threshold of IHL would apply. It is rarely the situations where an armed group comes to life and then does not meet eventually the threshold of international humanitarian law is rare. It's not that frequent, on the contrary. Now, the question is, what do we apply during that time? I agree, it is a problem which Jean Pictet addressed in his commentaries from 1958, and where he said that IHL threshold, and especially Common Article 3 threshold, should not be a high one, because otherwise they'll be left outside situations that should be governed by the law of armed conflicts. Unfortunately, that's not the case. That's not how jurisprudence treats it today. And also the new commentaries from 2016 of the ICRC still puts on some sort of a threshold. And so we do have 6 months in the Syrian conflict, but also in Boko Haram and other conflicts where as long as IHL does not apply, it is regulated by human rights law. Now, how do we define then armed groups under international human rights law? And we should, because if we want to apply to them human rights law during that period where IHL does not apply, then we have to have either a source for which we apply or a definition that includes them within those subjects of that law. So legal framework you have to find a way to apply it somehow. You cannot, you can, obviously, because the Human Rights Council has done so, and the Security Council has done so, and states are doing so. And if we just look at, now in the news it's very vivid, but in the 1701 resolution of the Security Council addressing violations, what Hezbollah should comply with as well, while Hezbollah at that time was an armed group, then we consider that they can comply with it. Though the question is, are they outside of a conflict? Are they addressees of that resolution? So it might seem to some of you kind of an academic exercise, and it is. But on the other hand, it has some practical implications. One of them would be whether the definition is the same definition as an IHL definition. Should it be the same definition? And what would it mean in respect to other measures of accountability for those armed groups? Does it provide with other possible measures of accountability? So one of the suggestions that has been there, let's cut to the chase. There are two suggestions on how to define armed groups outside the context of armed conflict. One is to use the definition that was provided under crimes against humanity, because crimes against humanity can occur both in the context of a conflict and outside the context of a conflict. So, and they should occur as part of a policy, a widespread or systematic policy of an organization or a state. So organization referring to armed groups, could be other organizations, but generally if you look it up, it's mainly armed groups. So whether this is a good source to define armed groups outside the context of IHL. Darag Murray adopts such a possibility and says, well, you know what? Yes, we can. We have to look at how organized, what is the requirement of what is an organization? So how the courts, tribunals, jurisprudence, scholars have interpreted this requirement for organization, this term, in the definition of crimes against humanity and the contextual element, and and draw from there. Draw from there the definition of armed groups. And surprisingly, what we see there is that there as well there is some sort of a command responsibility, so some sort of organization and coordination, and a lot of requirements that are not called, that we don't have the use of the word intense. But actually, when you look at what is intense under IHL, you would find similar requirements or indicators. But the main issue is that you have to have a command responsible, an ability to comply, capacity to comply with the law. And Murray uses this this definition. Wait, I think I found a way. An hour. Oh, great. And so that's one of the possibilities. The other possibility, is to look at the control exercise over territories and de facto regimes. Now, this is a suggestion that was made in different contexts, and I'll get to that in the past by Professor Yael Ronen, it's one of the articles I adore, so obviously I'm fond of, but suggesting that territorial armed groups that control a territory bear accountability, so have a definition, are subjects of international law by the mere fact that they have a de facto control. And because they have de facto control over a territory, human rights law stems from the state, it goes with the territory, And so they become de facto regime. They replace the state that is obliged to comply with human rights law, and therefore they have to comply with as well. So that's the source of application. Therefore, drawing from it the definition would be that an armed group outside the context of an armed conflict should exercise sufficient territorial control in order to be able to have the capacity to comply with human rights law stemming from that control, which is a bit circular, but it has its logic. And if it's a spectrum, then the extreme edge of that spectrum is de facto regimes. De facto regimes are what we may know, those of you coming from international relations and history, know that that's the way USSR was addressed through many of the years of its beginning. So considering it to be not a recognized state, but actually a de facto regime over Russia and other states joining to the USSR. Britain, for example, did not recognize the Soviet government to be the official government of Russia for many years, and considered it to be a de facto regime. It has its implications. For example, someone is born in Russia and has a certificate of birth, right? If we don't recognize the government, then that certificate of birth is invalid. Therefore, that person, if moving around the world with a passport, doesn't have a date of birth, a place of birth. I mean, doesn't have any papers that are valid. And so in order not to harm, and that's the point of having de facto regimes, is that in order not to harm the individuals, in order to kind of strengthen human rights, the rights of the individuals, of persons and people and the civilian population under such de facto regime, there is a de facto recognition. So we know they shouldn't be the regime, but we recognize them, if I put it simply, right? We recognize them anyhow to a certain level, and this is for the purpose of continuing and conducting some sort of relations to preserve the rights of the individuals. We can see that with Northern Cyprus. And if you remember, when I've mentioned at the beginning, the Agmoé adds to his requirement of capacity and ability also independence. And Northern Cyprus, according at least to the definition of independence in Darag Mourai's writing, would not be considered in some aspect independent, because it is a regime that was established by Turkey in Northern Cyprus. And so it is not fully independent. But for example, Hamas would be considered fully independent to a certain extent, because while it is supported in some way financially and monetarily by Qatar, it is independent in terms of political independence and so on. But for example, Hamas is a good example. Gaza is a good example of a de facto government in that sense, where people born in Gaza, they get a certificate of birth, and we actually agree that they were born there or dead there, and we take that into consideration. They have a laissez-passer, if they need medical assistance and so on, there is a registry, and we look up to that registry for practical reasons. So what is the level of control that needs to be exercised in order for us to say, well, you know what, that's enough. That's enough for an armed group to exist on its own outside a conflict, an armed conflict, obviously. And we can look at we have to find some source to define that level of control. One may look at the law of occupation for such source, because the law of occupation requires a certain level of control that would make the occupier replace the lawful government of that territory, and therefore take upon itself, not replace as in legally replace, but take upon itself the obligations of that government toward the population in the occupied territory. I mean, that's why we require some sort of control a level of effective control, saying, well, if it is effective control, then you can actually comply with all of the requirements of the law of occupation. Now, this level of control, of effective control, and the size of the territory that should be controlled, and requirements of boots on the ground, and replacing the administration, has throughout the years shifted away to some sort of a different approach, a functional approach, saying, well, you still have to have a high level of control, but it doesn't have to be replacing all the administration of the territory. It can be a lower level of control. Is that relevant for definition of armed groups? In order to, and I remind you, outside of an armed conflict, so in order for the armed group to be responsible and accountable and bear, to have a legal definition, so it can be a legal personality and bear responsibility, comply with international law outside an armed conflict. Pardon me. I think it's a good question. I don't think there is a good answer for that. I think it really depends on the agenda, on the policy that you want to adopt. We still hold armed groups to a higher level of a higher standard in that sense. So we still want them to be more organized than a failed state. We still expect them to be to have a better chain of command than a failed army. I don't think that Yemen as a state at the moment is better organized or coordinated than an armed group, but an armed group would have to meet that requirement while Yemen is still a state and is still subject to international law. And there is a reason for that. I mean, we expect state have the benefit of the doubt of existing in international law, while armed group, they establish, they're built, and they dissolve, and they change, and they shift, and so, and it's fluid. I suggest that in order, de facto regime require a government. It requires something that seems to be like a government. And so the level of control that should be exercised is one of effectiveness. It has to be effective. Otherwise, it cannot be a government. And we cannot de facto recognize it. I mean, international community and state. We can assume that a territory that is controlled to a certain extent, or that is influenced to a certain extent by an armed group, obviously is affected by that armed group. But because this is my belief, I am also not keen of defining armed groups irrespectively or regardless of the context of armed conflict, because I think that it asks us to find a definition that is difficult to find, and it goes along the line of whether we decide to recognize armed groups or not. And that's difficult in the, legally we could probably make some, maneuverings, but then practically it would be practical to enforce it on the ground. So it's much more it's easier for states, for actors in the international arena, to treat armed groups as part of a conflict, even in human rights bodies and in human rights organizations such as the Human Rights Council and its resolutions. And you can see how after, and it's an interesting, there is an article written by Ezekiel Hefez and another colleague exactly on how human rights bodies treat armed groups within their resolutions. And it's interesting to see the shift or the language that changes through time, especially let's take Syria as an example, but also Iraq and Daesh is a good example. At the beginning of the conflict, when it's violence and hostilities, but not fully defined as an armed conflict, a non-international armed conflict or an international one, and then how it changes once there is a definition of international, of IHL, so of International Humanitarian Law, saying this is a non-international armed conflict, and then the language becomes much more determined. And I don't think it's because the legal advisors change in the states, or the missions in Geneva or in the Secretary of the United Nations. I think it's also because it's easier to use such language when you know that the law has specific obligations addressing those actors.
1 minute.
Yes, I'm finishing. This is my last, yes, it's my last slide. So I think it's my lane. Woo. Okay, so a few points on that. When we speak about recognition, we tend to speak about what we know now when it's voted at the United Nations. For example, the vote on 2012 regarding Palestine. So whether we recognize Palestine as a state or not, or Kosovo later on. And so on. But recognition existed way before that, and it existed exactly in relations to armed groups being parties to a conflict. So again, in the context of IHL. And then recognition of belligerency existed, and it comes from the 19th century. And Lauterpacht wrote, the old Lauterpacht, the father, wrote many things about it, but in general what it aimed at is saying, well, once an armed group complies with certain conditions, and we have certain indications that it's fully organized, controlling a territory, is fully effective, then we will apply the body of law that applies usually to international armed conflicts, because we want to make sure not that they protect the population, nor do they fight better, but actually we want to protect interests of third parties. Which is interesting because, for example, the law currently of IHL also addresses in many ways third parties, for example, in humanitarian assistance and the obligations of third parties toward occupied territories, for example. It could be interesting to ask ourselves whether recognition of belligerency would be effective to ensure that third parties are either protected or have obligations toward territories controlled by armed groups in this respect. We spoke about de facto government and diplomatic implications of recognition in the slide before, so if afterwards there is a question, we can always address that. Now, regarding accountability, I said that maybe we should not adopt the classic approach to accountability. The classic approach is that we take someone to a judicial process, either the ICJ, regional mechanisms, individuals belonging to a group, head of states, international mechanisms, domestics, and so on. But maybe there is a flexible approach that actually is being used practically now in past years regarding conflicts of armed groups, because most conflicts today involve armed groups. And that's human rights bodies addressing their obligations, the obligations of armed groups in conflicts, sometimes outside of conflict context, but mostly in conflict context, and sanctions. So Security Council is imposing sanctions on armed groups, so defining them as terrorist groups and imposing sanctions on them. This is a flexible approach to accountability. They are being held accountable, not in the court of law, but they are being held accountable. Okay. So it's, in my opinion, adopting a flexible approach to accountability enables us to see, if I can sum up for a minute, enables us to see that it's true that states, and it would be difficult to change such concept legally, states are subjects of international law, and as long as we speak in the language of subjects and objects, states would remain the main actors. And I don't think I think we're headed in a way where the definition is more flexible, but I don't think we're headed in a way where states are replaced, are not subjects of international law anymore. What I think we are going toward is an understanding that the playground, the arena of international relations, the international community is being built, addressed, and addresses different actors. And these actors are not only states, and it doesn't mean that their contribution to that playground is less important than states, or may shift or may not shift the discussion in the future. Thank you.
The floor is open.
Please be kind. Yes.
Thank you for the talk. So I guess just as a starter, one, I think, obvious objection and one question of clarification.
Yeah.
So, in terms of the objection, I think this is very, very basic, but I think there's a reason why positivists, at least, tend to insist on the exclusionary nature of states as subjects of international law. And it has to do with the deep structure of international law as a system of peace and security, and with the idea that if you have some clarity around who bears responsibility, then you're able to perhaps create the right incentives for states to control armed groups. And the question of the responsibility of armed groups is really cabined in a very particular area of IHL, and that is, in non-international armed conflict, and it's really not a good idea to expand it beyond that, because you're making then almost necessary compromises, both in terms of this ability to create peace and security, in terms of having states responsible for those actors that are working from their territory, and perhaps in terms of human rights, because the IHL framework is much less protective of human rights in many contexts than just normal human rights law. So I guess on the more theoretical level, I'm wondering if you can address those points. On the more practical level, I just like to hear some illustrations of how your approach makes a difference in the real world, in cases that we maybe are somehow familiar with around us. You mentioned Hezbollah, you mentioned Daesh, you mentioned Yemen, one can mention Libya. I mean, there's a number of many areas in the Middle East now that have a very uncertain status in terms of who is actually in charge, and I'm wondering if you can illustrate how your approach would make a difference in terms of how we think of any one of these particular cases.
Do you want me to fetch some questions?
No,
or okay, thank you. I like those long questions. Okay, so to be honest, my starting point in all of my research is that IHL is the correct, the proper, actually, body of law to start to be the starting point of defining armed groups, because that's the, as you said, positivist, but also practically, this is the only body of law that actually has the term armed groups, that defines them. I can see why, I can see the incentive of going beyond that, because as I said, there are certain situations where we define the conflict from a certain point in time, and then before that, there is no law. There is law, human rights law, but then the question, who's responsible?
The state.
The state. Now, that's problematic, obviously. I mean, it's not problematic in theory, because then the state will be held responsible.
Right.
But it is difficult to imagine a situation whereby an armed group commits a violation of international human rights law. The state is expected to fight them, and the state is not that it doesn't affect internally the state. Now, from a positivist point of view, I believe this is the best way to achieve what we were trying to achieve with the ICC, and that's complementarity. So some sort of obligation from the state. But practically in the past few years, I've seen difficulty of states to comply with it when they go before human rights bodies. For example, Iraq, 3 or 4 years ago, in its report to the Human Rights Committee, admitted that it is not able to comply with, it's not only not able, but it is not, it doesn't have to. It doesn't have jurisdiction in terms of human rights obligations toward Yazidis in the Sinjar area because it doesn't control it anymore.
So maybe that's a reason to recognize Daesh as a state.
But we will never achieve recognizing Daesh as a state. And so we're stuck, and Lisbeth Zegveld said it already in 2001, we're stuck in a situation where the only way to hold armed groups accountable is to have individuals, members of this armed group, held accountable under criminal law. Now, I'm with you. I think IHL is the correct body of law to govern the actions of armed groups. But we have to be able to see practically how it looks on the ground. And maybe it's either saying, you know what, then human rights bodies don't have jurisdiction. So let's erase La Tablada case, 20, 30 years from, ago. Let's say we don't use that anymore. Human rights bodies and don't have jurisdiction over IHL situation. So the Human Rights Committee cannot address Iraq's responsibility or jurisdiction on human rights violations versus the Yazidis in Sinjar, because that's a situation of that is governed by IHL, and so let's treat it through bodies that discusses IHL, which are none. And again, you see what I'm saying? No.
I have to admit that I don't.
Okay.
But, it's fine. Maybe other people.
What would be? Let's see. What would be your solution? Your solution would be Iraq is responsible for the violations of human rights committed.
Either Iraq is responsible, or it's a separate state, and then you have to recognize it as a state. And I think at the time, there were discussions regarding the possibility of recognizing it as a state.
Definitely.
So it's not so off the wall.
Oh, no, not at all.
And so I don't think that we have this vacuum that you're describing, or rather that if we recognize it, we're creating further opportunities for kind of giving up this idea that the world is kind of divided into this puzzle of states that have actual control over the territory and that have full responsibility in all the legal public international law senses. Now, I may be wrong, and I may be...
No, it's a discussion. There's no
it's
wrong
possible
and right
to
here.
Maybe it's possible to convince me, but maybe other questions will help doing that. I don't know. Or maybe an illustration, an example where that would help.
Help as in changing adopting
if it
a
would be
flexible
positive
approach
from any perspective whatsoever, to recognize armed groups as a separate actor.
Oh, I don't think you should recognize armed groups as a separate actors. I myself, in person, I disagree totally with the writing of. Not totally. I like some of his points, but for me, the idea that Murray tries to convey that armed groups can be defined outside of any conflict context is. I find it difficult. I see what is appealing about it, which is that you have as I said, a period of time where armed groups do not fall within, their actions do not fall within IHL jurisdiction, so IHL framework threshold is not met. But I think it would be difficult. The only thing that I do respect is Ronen's idea that if you have a de facto regime, so an armed group that controls sufficiently a territory and is found able and capable to comply with human rights within that territory, then you can apply that human rights through that. But then you have this measure of effectively controlling a territory. As me myself, I don't think you should even recognize them as state. I think you should recognize them as occupiers. But that's another discussion that is outside the scope of this presentation. What I do think, and this is something that has also been mentioned by Catherine Fortin, is to adopt a flexible approach to accountability, saying, well, you know what, it's true that there is a certain period of time until IHL kicks in, but that doesn't mean that you cannot have measures of accountability applied to those armed groups during such time. And these measures are through human rights bodies, either forcing states to comply with human rights law, or forcing or adopting sanctions toward those armed groups specifically, like we had with the Security Council toward many, financial sanctions, economical sanctions, traveling and so on, blacklist, etc. So I'm with you on that. Actually, I don't think we can define armed groups outside the context of, I just think there is another way. Yes.
Yeah, thanks. Three points. One is, when I saw the title, I wasn't really sure what you're going to talk about, in the sense that we can think about at least two things with relation to the status of armed groups. One is whether it regards accountability and what are the obligations, and the second is the lawmaking ability. And I wonder to what extent do we think that it's related? What's your position regarding it? Does it matter to your piece? Because actually I was
hoping.
No, I thought that this is where it's going, and I think that it's an important conversation whether if you want to see them as subjects of international law, what are the reasons that we exclude them from lawmaking powers, at least with regard to the relevant norms? So this is the first question. So maybe a clarification, and what should be the role of the discussion regarding lawmaking ability of armed groups? And in this regard, I usually tend to think that we should stop thinking about Daesh or Hamas or Hezbollah in this regard, but about legitimate rebellion by miserable people that are being ruled by a dictator, and they are involved in a guerrilla warfare in order to establish a new regime. No, just in matter that the emotions of these are the bad guys that just burn people alive is out of the picture. We might think about more clearly whether they should have a say in creating the norms that control their ability to use force in this regard. And we know that there are strong biases towards states in the regulation of warfare that enable them to fight more, to win more easily, even with respect to issues that do not involve the direct targeting of civilians. The second is that I wasn't sure along the way whether your argument is positive or normative one, and I think that it matters a lot for the discussion. So, for example, when you say that you really like Yael Ronen's position, whether you like her as a positive articulation of current law, or this is the direction that we should go to, I would want to hear more. And I think that especially because the easiest way, right, is just to say, okay,
that's the law,
right, and if not, and I think that it's an important discussion, then I'm not sure in what way does the discussion of the role of armed groups is different than the discussion of other non-state actors as bearers of obligations, and should it be different? I think that it needs to be part of the discussion. So when we think about human rights obligations of corporations, is it different than armed groups? In what ways? Why should it be different? And so on. I'm not sure that normatively it's extremely different. And the third and last point is that, again, well, we didn't read the draft paper. It wasn't clear enough, at least to me, what is your core argument. I heard lots of positions of different scholars, and I want to hear. I'm not a huge expert on the literature on armed groups, but I read some, and I just want to know what's your voice. Where do you add to the existing literature?
Okay. It's okay if I take it straight away.
Yeah.
Okay. I'll start from why is it important to define whether armed groups are subjects or not? I think I'm going to mix your first and second question by saying that I'm a radical in the sense that I think the system currently, the differentiation between subjects and objects is not irrelevant. It is, because states are still lawmakers, but when discussing the system, the international system, it would harm the discussion to disregard armed groups or any other non-state actors for that matter, but specifically armed groups, and specifically in context of armed conflict, just because from a positive perspective, they don't have the power of lawmaking. Now, which is not fully true, because actually IHL foresees a possibility for armed groups to sign treaties with states or among themselves in order to comply with IHL obligations. So within the framework of IHL, we actually provided to some extent armed groups with the ability to be lawmakers. And this is from a positive point of view. A normative point of view would also, but not only a normative point of view, but a normative point of view, a realistic one, would say that customary international law, so not only based on law as it is in treaties, but even before that, the emergence of such law, the process of an emerging law, is especially in IHL, but not only, currently also in human rights and in criminal law, is affected dramatically by the behavior of armed groups. And so looking at them in soft law as well, and specifically maybe generally soft law, because most of the decisions regarding are taking place, the emergence of the law regulating how armed groups behave is created by their inclusion, in a sense, just by talking about them. I think looking at them within this very narrow perspective, subjects or object, would harm the discussion, in my opinion. And so I'm a radical. I propose something else. I'm just saying, you know what, let's put that aside, whether there are subjects or objects. Let's look at them as players. And why is it relevant? Because as long as you're not part of it's not true, not as long as you're not part. But if you take the discussion of subjects and object, the question that always rises is whether if you're a subject of international law, then you also bear accountability for your actions. While if you're not, then the question is, how can you be judged? How can you be held accountable by the international courts, tribunals, mechanisms? So it is linked to one another. States have they benefit from being subjects of international law, so they are lawmakers, they take part in the arena, they are members of the United Nations, they sign treaties, they have the power of state investments and so on and so forth, diplomatic immunity, you name it. But they also bear the responsibility or the obligations or the duties of being subjects of international law, and in general that means that they can be held accountable for their actions as a state, not as individuals. So the discussion of whether groups are or not subjects or objects of international law is often used to say, well, as long as it has, let's not recognize them, because if we recognize them for the sake of duties, of imposing, of holding them accountable, then we also recognize them for the possibility of them being part of the law process, being part of the arena, having real role, being equal to state in a sense, and we don't want that. So, and we see that we don't want that, states don't want that, because even in recognition of belligerency way back in the 19th century, when we recognized armed groups for the sake of a conflict, it ended once the conflict ended. and it was very limited. And we see it in Article 3, in paragraph 4 of Common Article 3 to the Geneva Conventions, which is the same article that convey that armed groups can sign and ratify treaties for the sake of the conflict, so for ensuring compliance with IHL, like the armed groups, the actors in the Balkan War in the 90s did actually. But it mentions there explicitly that it does not change their legal status. So we are not there yet. I mean, if I were a true positivist, I would say, well, we're not there yet. It's within IHL. It doesn't change the status, and therefore accountability of armed groups can only be, in terms of from a positive perspective, can only be found in criminal tribunals toward individuals. And it would be correct to say that, but from a normative perspective, we are no longer there. Because you say, let's not look at Daesh and at Hamas and at Hezbollah or Boko Haram, but this is what is going on, and armed groups are taking, northern Syria is currently controlled by a proxy of Turkey, that is the Free Syrian Army. Now, to ignore that, or to say they do not affect anything, and if we cannot hold Turkey responsible for that, then we don't do anything, would be a mistake. Because it would mean practically on the ground that victims of hostilities are not being fully protected. And so maybe and that's to your third remark shortly, is that maybe my core argument is that while we take all of this into consideration, and while I understand that from an academic point of view, it would have been amazing to include armed groups as subjects of international law, to take them outside of the scope of IHL, it is not practical. It's not. ISIS, it was considered to recognize it or not. Can we say it's a state or not? It wasn't. And there are good reasons, but I mean, Catalonia is not being recognized, though they voted on it. There is a reason for that. And so we have to find another way. And the other way for me is just to widen the spectrum. Is to look inside IHL what provisions can be used to enhance protection and enhance responsibility of armed groups, so we can apply as much as possible human rights law and IHL to the actions of armed groups within their operations, and from the other hand to understand that accountability is measured, accountability to subjects and non-subjects, so whatever language you choose, accountability is measured not only in a way of tribunals and judicial process, but in other ways as well, and we are there already. I mean, it's something that happens in the past decade or two. It's not something new. As to your question on cooperations, on corporate responsibility, human rights obligation, I think there, the only reason it's easier, it's not easy at all, because there's a lot of financial arguments and incentives and economic incentives, is because any cooperation has to be registered within a state. So even transnational cooperations, they have a headquarter, a place of registry, or several. And then the discussion regarding human rights obligations is legally easier, because it would mean that you would go into the state where that corporation is registered, or the states where it's registered, and you would ensure compliance of that state. So if I have a corporation that is listed in the Netherlands and I feel that that corporation is violating human rights law, I would go to the Dutch court, and I would be able to petition there for the state to oblige the corporation to comply with international human rights obligations. While armed groups, unfortunately, are not yet registered anywhere. And so having them, wanting them to comply with something would have to mean that we have to find what we want them, and what are also the benefits that they gain from complying with it.
Can I follow up on that?
Sure.
it seems that you're putting a lot of weight on the question of registration, rather than which is a very, very formatic test. Where on everything else you're trying to avoid from formalities. And if we go back to Itamar's question, if you actually combine Yali's and Itamar question, you're saying that you would go to the authorities with regard to the corporation's violations on human rights. Well, you just told Itamar that you cannot go to the state if the armed group is in control of the area. So if the company doesn't want to cooperate with human rights and it has enough power to not to ignore the authorities, then you're in that exact position of a non-state group, not necessarily an armed group, but a non-state group that does whatever it wants without any accountability.
Yes and no. I wish to clarify because I might not have been as clear as I thought I was with Itamar's question. I think states are the ones to go to when an armed group is committing violations of human rights law. But practically, states tend to say they control. I mean, they didn't used to do that, but they didn't do that in the past, but they are doing it now, especially since ISIS emergence. I don't know how to call what the phenomenon of ISIS, but it's not only that. I mean, the Lebanese government regarding south of Lebanon with Hezbollah, many areas in Nigeria controlled by Boko Haram, Congo in the territories controlled by armed groups, several armed groups in Congo, CAR, and so on. I mean, it's totally not. It wasn't invented by Iraq, and ISIS. Iraq was just the first one to put it on paper, and using it as a legal argument of saying there is lack of jurisdiction. But it's not new. So in that respect, I agree. The address to go to would be the state for human rights violations. Unfortunately, and unlike in cases of corporations, in what regards armed groups, because of the political implications, states are not as inclined to take responsibility. And I can see why. I mean, practically, they are in a war, in a conflict with that group. While with corporations, they are in a way in a war because you want to attract as many investments as possible and you want to be as attractive as possible as a state for foreign investment. But then, as a lawyer, I would say then it's less controversial because at least I have something tangible to use. But it's also very difficult to have states comply with. Actually, it's very difficult, and sometimes even the language used by states versus armed groups against armed groups is so much better, so much more engaged than what they use toward corporations because obviously the financial incentives. It's actually very hard to have states comply with to have states ensuring corporations complying with human rights law. Just from a legal point of view, it would be easier to frame it. I'm not saying practically it is easy, otherwise you wouldn't have 6 or 7, how much is it already, forums of the United Nations discussing exactly the same thing on business and human rights and having states attending and saying exactly the same thing without any ability whatsoever to provide with a treaty that actually conforms with human rights in business. But at least from a legal point of view, it's easier to act upon. Who do you sue when an armed group is, when an armed group is not? I mean, you would go to the government, obviously. Yeah. But what you do see is the mechanisms of criminal procedures that are actually they're good from a transitional justice point of view. They enable a narrative to exist, and they do give some sort of committees and criminal committees and investigations. They do give a record of what has happened, and perhaps in the future one would be able to sue Iraq for the damages that occurred during the fight against ISIS.
So far you had questions from international law people and maybe I'll add something because this discussion seems to me a bit anachronistic from different perspective. But first, just a clarification, I was intrigued by the fact that you said that the UK didn't recognize the Soviet Union because I teach exactly the opposite, that they actually accept the Kelsenian approach to effective basic norm, and that's the reason that they recognize Taiwan 14 years before the US, so it doesn't match. But with this anachronistic approach of international law, you're talking about armed groups, and the question, of course, what is an armed group and why is the armed so important in our days where you can have groups that inflict real harm through cyberspace without any weapons. The whole issue of armed group might not be really a good distinction. You talk about control of territory. In our age, we talk about control of people without any territory, and you have either governments or various groups that can have much better control on people's behavior without any control of territory. So what is the relevance of territory in our day age? I think the whole issue is the result of a very long historical kind of identity crisis of international law, right? International law was born as a law regulating relations between states. And then when it started to enact human rights treaties in which the protection is not states but individual in states, there was immediate conflict. How can we enforce states to compel to their obligations towards individuals? And we talk about philosophy of law, of legal theory, this whole distinction between subject and object is really archaic. Every person who is legal person, natural legal person or unnatural legal person who is a subject to duties or rights is an object and a subject of law. Okay, and in a sense, it seems to me, I don't know if that's correct analysis, that the whole debate is trying to reflect interests of states, and it's usually very, very small segment. No, maybe it's not small segment of states. Maybe it's also an alliance between different states, to avoid actually imposing responsibility on them for infringing individual rights in their territories, right? And therefore, you have all these issues of who is a subject and who is an object. And if you solve this problem, that everybody who has rights and duties under law, including international law, is the subject, then you solve the problem. In addition to that, if, again, from a philosophical perspective, if individuals are responsible or accountable in international law, and you can bring individuals into International Court of Justice, International Criminal Court, and states are responsible, everything that is between individual, any incorporation of people, is also a legal subject. So whether you bring the individuals as individuals or you bring the individuals as a group is really a minor subsidiary question in this debate.
I like your philosophical. No, seriously. So I'll clarify your remark on UK and USSR. When I used the term recognition, I meant de jure recognition. So the government, then the USSR, in the first few years was not because of its because of the Cold War, because of the expansion, was not recognized as the legal de jure government by many of Western states. Eventually, UK was actually the first one to say, you know what, let's have a de facto recognition. This is a de facto regime. We have to, which is the same approach they had with Taiwan, because practically we have to continue some sort of exchange, and the only way to do that is to recognize this is the government that we talk to. So it's exactly the same point of view. It's a de jure versus de facto recognition.
In a very interesting way, plays paradoxically the opposite way about Palestine.
Yes, definitely. But yeah, we can have a whole new discussion on whether we should de facto or de jure recognize Palestine. As to cyberstate and territory, I really like this discussion. I think that in the past, when we addressed territory, we did address it as a part of a land. Currently, the interpretation, also in the law of occupation, has become that you would apply the same provisions, not the same to some extent or with mild differences, if you have custody of persons. So if in the past effective control addressed mainly the custody of land, now it addresses both the custody of territory and persons, and which incorporate also cyber acts. I'm sure you know that
it goes before cyber. You know, there is a fantastic documentary series. Our son obliged us to watch it about this sect, Indian sect, right? That they, you know, so mental control,
mental control. So and I'm sure probably researchers in this facility institution know better than I do on cyber and how it interacts with IHL, but IHL foresees cyber as being cyber attacks as being the same as any attack, armed attack. So the use of armed is totally, could be understood as well, could be interpreted as well as including within that definition also cyber attack. As to whether the discussion is anachronistic or no, you're preaching to the choir. I don't like the discussion of subjects versus object. I'm more of a pragmatic person. I think that you have to look on the ground, see whatever is going there, and ask yourself whether the legal provisions that you have before you can be adapted properly in order to guard as much as possible their spirit. So in a way, coming from international humanitarian law and international human rights law, I would say that it's better to look at the law that you have at hand and see whether you could apply that law mutatis mutandis, so by analogy, to the current situation, irrespectively of whether it's possible from a positive point of view. So I agree with you. I have to make a point on that it's true that one could say between an individual and a state, you could have a spectrum, and as long as you hold individuals responsible before an international criminal court and state responsible before the International Court of Justice or whatever mechanism that we have, then everything in between them can be held accountable as well. But the truth is that we don't have any body of law that could actually do that. So we don't have a judicial body in international law that has the capacity to do that. You cannot judge states before the ICC, nor can you judge corporations or armed groups for sure, just individuals. And before the ICJ,
you know, it's a question.
It's a question of definition.
Yeah, if a German criminal court can adjudicate a criminal proceeding against a corporation, saying that the corporation may have mens rea and actus reus. And of course, in the international
definitely, then we have to go domestically, and the African Union actually has incorporated a provision that allows for corporate criminal liability for international crimes, which is impressive, but we only have it at the African Union. I'm done, I think.
Any other
last remarks? Taking a photo. Yeah, no, sorry.
No, maybe it's from the political scientist point of view. It's just a small remark, maybe that aims in the direction that we also did before. Like, I was asking myself exactly like this definition that you had before. Now we're talking about ISIS, but if you look, for example, in the past, like we had in Germany, like the Red Army Fraction, which would be also an armed group, and you could discuss, like, what are they? Are they like freedom fighters or a terrorist group? And then you would label them, and you wouldn't, like, the state wouldn't deal with them anymore. And I think it's but it's a general discussion of if it's like terrorism or like a freedom fighter.
There is a saying that one's freedom fighter is another one terrorist, and therefore the whole discussion of freedom fighters versus terrorists versus armed group, for me it's an important discussion because it tells a narrative. So from a historical point of view, a philosophical point of view, even from international relations point of view, I think it is important because it gives voices, but from a legal point of view, I find it mostly harming. because it helps using legal excluding actors or excluding groups from a legal framework that they belong to just because you name them in a certain way. Hence, look at the Polisario. This is an amazing example. The Polisario is the armed groups active in the West Sahara. They're an armed group. They have joined additional Protocol 1 to the Geneva Conventions by making a unilateral declaration under Article 96, which means that they took upon themselves to comply with all of the provisions of the protocol, so complying with IHL, whatever. They are considered to be the example for freedom fighters, and still their leaders are marked in Morocco and in other countries as terrorists, to the point where when traveling to Switzerland, they had to get a special flying diplomatic protection, so Switzerland is not forced to extradite them based on extradition agreements that it has. So in that sense, I think it's an interesting discussion, but I admit that it's a discussion that I don't like having when talking about obligations, duties, and rights of armed groups, because we tend to say, oh, they're terrorists, or freedom fighters, and based on that, apply whatever we feel like.
Thank you very much.
Thanks a lot.
And next week?
No, January 6th.